not here to deny people a right. We're here to fix a wrong. They said it was over. Is it over? We're seeing something unprecedented in our island's history. We're putting aside our personal feelings about politics, our preference for a given political status, our differences in our place of birth, different languages, our differences in many ways, just to unite behind a single cause of Chamorro self-determination. We are the people of Guam who look out for each other, who respect each other, who understood that Chamorro hospitality and the half-a-day spirit was not an invitation to deny fundamental right to choose a political future. We are not dividers. We are uniters. We're not seeking to fight with others. We are promoting peace. That's why we are here arm in arm, step by step, marching, walking in the full view of our ancestors who came before us and are this moment watching us. Maila, come with us. Fanoki, Kahulu, Kalamtin. Move forward with one clear voice that will not be silenced, that will be heard here in Adelup, over there in the federal courts, in Washington, D.C., in New York, wherever there are people who make decisions about us. They must hear the echoes of history, the cries for justice, the voices of the people who are gathered here this beautiful morning. Let them know that you are here. Are you ready? Biba Guahan! Biba Guahan! Nalagang louder! Biba Guahan!
Our first speaker, let's welcome to the stage the Honorable Felicidad Ogumoro.
Allow me to share a very brief political history of the Northern Mariana Islands, or NMI. Following the end of World War II, the Northern Marianas was one of the 6 districts in Micronesia that were administered by the United States pursuant to Security Council Resolution 21 as part of the United Nations Trust Territory of the Pacific Islands, also known as TTPI. It is important to note that Article 12 of the Article 6 of the Trusteeship Agreement mandated the United States as a trustee to move the TTPI towards economic advancement and self-sufficiency, and to protect the inhabitants against the loss of their land and natural resources. The federal designation of the Marianas Trench Marine National Monument, and 3, the federal ruling that Article 12 of our CNMI Constitution, which governs land alienation, is discriminatory. The United States recognized in Secretarial Order 2969, promulgated in December 26, 1974, that the trust territory of the Pacific Islands held title to the submerged lands and waters adjacent to the NMI. When we voted to approve our covenant, all the, quote, real property in the Northern Marianas, end of quote, held by the trust territory was then transferred to the government of the Northern Marianas. The United States further acknowledged the rights of the CNMI to the submerged lands and adjacent waters in its lease of 2 of our islands. The 1983 Tinian Lease Agreement explicitly leased to the United States the quote, waters of the Commonwealth immediately adjacent to the leased surface lands on Tinian and Farallon de Mendeniza Islands, end of quote. The United States acknowledged in this lease agreement that, quote, the Commonwealth retains the right to exploit the living and non-living resources of the waters immediately adjacent thereto, close quote. Such a lease would have been unnecessary if the people had no rights to these waters and submerged lands. The CNMI has always recognized the property rights of its people to these submerged lands and adjacent waters. Article 11 of our Constitution, which was approved by the President of the United States in January 9, 1978, states that, quote, the submerged lands off the coast of the Commonwealth, to which the Commonwealth may now or hereafter have a claim of ownership, are public lands belonging collectively to the people of the Commonwealth who are of Northern Marianas descent, close quote. Our legislature adopted in 1979 the Submerged Lands Act, and in 1980 the Marine Sovereignty Act. Both of these were designed to govern the waters and resources of the 200 nautical mile exclusive economic zone surrounding the CNMI. To conclude that the United States somehow gained title to the submerged lands and adjacent waters when our people had no intent to convey those lands and waters to the U.S. is illogical. Furthermore, no other method of property acquisition by the U.S. has been identified. Despite the clearly established transfer of the submerged lands and adjacent waters to the CNMI government in Section 801 of the Covenant, the Ninth Circuit Court of Appeals reached the opposite conclusion in the case Commonwealth of the Northern Mariana Islands versus United States of America. In its opinion, it ruled that the Commonwealth and its people had no property rights to these submerged lands and adjacent waters. The opinion, on the one hand, recognized that all, quote, the authority of the United States towards the CNMI arises solely under the covenant, close quote, but then, on the other hand, cited the paramountcy doctrine to conclude that Section 801 of the Covenant did not apply to the submerged lands and adjacent waters. The Ninth Circuit Court based its conclusion on Section 104 of our Covenant, which recognizes the responsibility and authority of the U.S. over foreign affairs and defense matters, but ignored the language in the Covenant that specifically addresses leased property to the U.S. The U.S. has therefore wrongfully asserted ownership of our submerged lands and adjacent waters in violation of its fiduciary duty under the Covenant. That contradicts the Covenant and the principles of self-determination that govern the negotiations between the people of the Northern Marianas and the United States. To address this problem, I introduced on January 13, 2014, House Joint Resolution 18-1, which was adopted by the 18th Northern Marianas Legislature, asking the U.S. Congress and other agencies of the U.S. government to return the entire submerged lands and the adjacent waters to the rightful owners, the people of the CNMI. As descendants of Chamorro and Refaloash voyagers, the waters surrounding our islands have sustained us and have always been a significant part of our culture, our way of life. The introduction and adoption of this joint resolution was an important step in our quest to win for the people of the CNMI the respect, rights, and ownership of what is rightfully ours. As of this date, the U.S. has yet to act on our requests. Our rights, which are guaranteed under the covenant, are slowly being chipped away right before our very eyes. If nothing is done, we stand to lose all that we have hoped and worked very hard for in our quest to become self-governing and self-sufficient. We would be left with a covenant with no protection for our people, whose lands and resources the U.S. deems strategically valuable. Another example of federal government action taken that was contrary to the spirit of the covenant is the presidential proclamation that was signed in 2009, which established the Marianas Trench Marine National Monument within the waters of the Northern Marianas. With just a stroke of his pen, former President George W. Bush laid claim to thousands of miles of our waters, our submerged lands, and our resources. When Pew Charitable Trust first proposed the idea of a marine national monument to former Governor Ben Fitio in 2007, his response was that the administration was not prepared to embrace the proposal, stating that, quote, given our valuable natural resources and their potential uses, the CNMI government must fully consider all options and decide carefully, prudently, and strategically, balancing environmental, social, cultural, and other considerations in deference to our local constituents and stakeholders, end quote. In Senate Joint Resolution 16-4, the 16th Commonwealth Legislature respectfully requested that the President of the United States refrain from unilaterally creating a marine national monument without the consent of the local government. In addition to our legislature's position, our mayors came out against the monument designation, as well as many of our indigenous citizens and local leaders. Clearly, our people's and leaders' opposition did not matter, as approximately 95,000 square miles of our waters and submerged land became a national monument in January of 2009. When former President Bush designated a portion of the Marianas Trench as a marine national monument in 2009, was that designation really about conservation? Was he telling us, the people of these islands, that we are not capable of managing our resources? What about the minerals identified in the seabeds in the Marianas Trench? All of this begs the question, what is it about, what is it that our submerged lands and waters contain that we are not cognizant of? Are there other resources which we are not aware of? When the presidential proclamation states that the submerged volcanic areas of the Mariana Ridge, the coral reef ecosystems of the waters surrounding the islands of Uracas, Mauk, and Asuncion, and the Marianas Trench contain objects of scientific interest, shouldn't we have that right to explore, discover, claim, and make use of these objects as we see fit for the betterment of our people and our island communities? It seems to me that we have an abundance of resources, except that we are being denied the right to these resources. The last example I want to share today relates to ownership of our lands as defined in Article 12 of the CNMI Constitution, namely the acquisition of permanent and long-term interest in real property within the Commonwealth shall be restricted to persons of Northern Marianas descent. For purposes of determining Northern Marianas descent, a person shall be considered to be a full-blood Northern Marianas Chamorro or Northern Marianas Carolinian if that person was born or domiciled in the Northern Mariana Islands by 1950 and was a citizen of the trust territory of the Pacific Islands before the termination of the trusteeship agreement. As I try to understand the significance of land to the cultures and traditions of the indigenous of the Northern Marianas, I came across a moving quote, which is not only inspiring, but has made me all the more determined to fight even harder for what was handed down by our ancestors, our land. Quote, "There is often an inadequate understanding or recognition of the fact that land is more than a resource for indigenous people. It is the basis of their existential, social, and cultural reproduction. It is a territory, a sacred territory, whose place names contain their past and present history, a cultural landscape where their founding heroes have walked and where their ancestors and their dead rest, a framework that comprises the very essence of their society and the basis of their culture." In 1992, in the case of Wabo versus Villa Cruces, and again in 1996 in Diamond versus Matsunaga, the U.S. Court of Appeals upheld Article 12 of our Constitution. The term persons of Northern Marianas descent was not considered a racial classification. Sadly, however, on May 20, 2014, in the Davis versus the CNMI case, the District Court of the CNMI ruled that persons who were not of Northern Marianas descent could vote on initiatives related to Article 12. That disheartening decision was upheld by the U.S. District Court of Appeals, by the Supreme Court, which decided that persons of Northern Marianas descent is a racial classification, and therefore restricting voting on all initiatives pertinent to Article 12 to only NMDs violates the 15th Amendment of the U.S. Constitution. There exists the opinion that the Ninth Circuit's 2005 decision is particularly troubling because it fails to recognize that the covenant emerged from a unique self-determination process, and the court's decision reinforces the view that the Northern Marianas are not now self-governing and that the self-determination process is incomplete. Indeed, if the Ninth Circuit's 2005 opinion is correct, and if the U.S. can take property from and override the clearly stated wishes of the people of the Northern Marianas descent, then it follows that the covenant was not a successful act of self-determination, and the persons of Northern Marianas descent continue to hold the status of non-self-governing persons and thus continue to have the right to self-determination. The United Nations has made it clear that a successful self-determination process must result in one of three possible outcomes for the formerly non-self-governing communities: independence, integration with a former colonial power, or a free association relationship. Can we honestly say that the United States has fulfilled its mandate to allow the people of the Northern Marianas to exercise the right of local self-government as guaranteed by the covenant? Or can we really truly say that the sovereign act of self-determination has really taken place? As a result of these various actions taken by the U.S., I introduced House Bill 19-2 on February 6, 2015. Thanks to my colleagues in the 19th CNMI legislature, the subject bill was passed and signed into Public Law 19-63 by our Governor Ralph de Leon Guerrero Torres. The act formally established the Second Northern Marianas Political Status Commission to do the following. 1, examine the present political relationship between the Northern Marianas and the United States. And 2, determine whether the people of the CNMI are still in favor of the Commonwealth status or prefer some other political status that would help them better achieve or fulfill their hopes and aspirations of a self-governing Commonwealth. The 11-member Second Marianas Political Status Commission has been fully organized, with 5 members from Saipan, 2 from Tinian, and 2 from Rhoda. At this point, I would like to recognize the presence of 2 of our commission members, Political Status Commission members, Dr. Elizabeth Rehebe and Mr. John Gonzalez. The President of the Senate and the Speaker of the House are non-voting members. And I understand that public meetings are scheduled to begin next month. The Commission will present its findings to the CNMI legislature for its approval or disapproval. The legislature will then present the political status option or options to the people of the Commonwealth for their approval or disapproval in a plebiscite that will be conducted 90 working days from the receipt of such recommendation by the Commonwealth Election Commission. Through this evaluation process, the question of whether the Commonwealth is truly self-governing as mandated by the Covenant will be addressed. The issues of self-governance will be fully explored. And furthermore, the goal of economic self-sufficiency through our relationship with the U.S. will be examined. If our people are not on the path towards achieving and attaining our aspirations, it is imperative that we find out why and what course of action should be taken to remedy this. It is important that effective public education be conducted in order for us to successfully examine our present political relationship with the U.S. Before the next plebiscite is held, our people must take stock of what has taken place since we became a part of the American political family. We owe it to our people to do a better job of public education so that critical issues can be clearly defined and understood, so that if and when a plebiscite occurs, the voting that takes place is informed. In conclusion, there is no doubt that there have been mutual benefits between the Northern Marianas and the United States over the course of our relationship. However, we, the people of the Northern Marianas, still expect nothing more than for the U.S. to recognize, respect, and honor our rights as a people as guaranteed under the Covenant, that our people be allowed to exercise our rights to govern ourselves pursuant to our Constitution, approved by the President when the United States, which was approved by the President of the United States. It is fitting that this conference is being held this month. Each September, the CNMI celebrates Cultural Heritage Month, where we highlight our unique cultures, celebrate our past, and gather to honor our ancestors. With that said, I am honored to, and in humble gratitude to our sisters and brothers from Guam for allowing all of us this space to share our stories. Our indigenous experiences, although unique, are similar and sadly common across the globe. In these experiences, we strengthen our solidarity to move our people forward to truly exercise our right to self-determination. Sizus Maasi Zantirong.
To me, I just want to point out at this time that it was very disturbing, because I do not believe that the people were fully informed before they went to the polls. Had we had more education on the status, I think we would have gone over some of the complicated issues that needed to be resolved, and good understanding of what that covenant, what that relationship looks like, and how is it going to benefit us. We need to do this examination, this assessment, reassessment, in a very, we have to give it time. We have to go and really do a good job in making sure that the people express their thoughts, but at the same time know that they know what had actually happened. Because if they do not know the facts, they are not fully aware of all the things, especially those that I pointed out in particular in my deliberation or my presentation yesterday about our submerged lands, our Article 12 that restricts voting to to only persons of Northern Marianas descent, and how what has happened to that, and all other issues relating to our immigration, what is now happening with the military's desire to conduct live fire training on our island, very precious islands, island of Pagan. Those things need to be brought to the front and be discussed clearly to the people so that they understand what is actually happening. It is then and only then that I feel that we should be ready to go and have a plebiscite. Let's not forget that we have been able to, the two sides, the U.S. and we have the people of the CNMI have also been benefiting from this relationship. But that it is important that we talk about what we feel has happened to us as it relates to the covenant, the agreement that we entered into with the United States. We cannot just ignore and move on and let these issues be unresolved. So in my presentation yesterday, I'm very firm in that if we know that there are things that are not going as guaranteed, our rights are not protected as guaranteed under the covenant, then we must speak out and take action. With regards to Guam, I am in favor and I'm in support of this movement that in solidarity we move the region, all the regions that are able to participate with us to help Guam fulfill its desire to exercise its right of self-determination, decide on what political status it wants to have for its people.
First of all, I'd like to pay acknowledgement to the land that we're on, to the Indigenous people's land, to our elders past and present, and to the land that always will be, always was Indigenous land. Thank you. I'm pleased to be here at Guam, and I appreciate this invitation to speak, and I especially thank Lisa, Melvin and their team for what they've done in bringing me here. I am honoured to be part of this conference and for the conference organising to bring our minds together as Indigenous people and as one in unity. As you're aware, I'm the CEO of the National Aboriginal Women's Alliance in Australia. I'm also an attorney and an adjunct professor in health. I've been working in the international arena for many years, and I've been working nationally and locally for many, many more years. and that is working with Indigenous people for our self-determination. I will be speaking about how, on a national base, how Indigenous people from Australia have made some necessary steps to overcome the shackles of our past, decolonisation, and using our rights as Indigenous peoples. For us as Indigenous people, we were never included in the laws and policies that were put in place to exclude us. We are now rising together. Even though we're low percentages in each of our countries, we are 350 million human rights movement in the world. We are the largest. And we will continue to rise as the largest human rights movement in this world. We are the same as a tree holding on to the earth. We are dependent and rooted to the earth. We need water, we need light. Without the earth, we would not be here. That is why we say, our mother. Our base of reflections of who we are come from our culture, traditions, values, and creations. Some Indigenous nations have been able to hold on to their traditional knowledge, and with that knowledge, we have instructions of how we conduct ourselves on the earth together with Mother Earth. Indigenous peoples, we have always respected our obligations and duties to our Mother Earth. We have been in constant warfare, but we know we have a duty and a set of rules for democracy, justice, and people and our Mother Earth. Our process was given to us thousands of years ago, and that is why we are able to remain resilient. As Indigenous people, we have grown, but we have not forgotten our past of our history, colonisation. Colonisation is the practice of control and power. Colonisation concerns itself with conquest and exploitation of the land, water, resources, labour and lives of Indigenous people. Colonisation overpowered Indigenous people by using slavery, murder, displacement, theft, abduction, rape, genocide and religion. Colonisation is not something that just happened in the past. It continues to echo for generations and through a system of colonial processes and structured. It has been embedded in our laws, policies, beliefs and values of the white settlers. We live under this legal framework and policies, so we have to find ways to challenge these frameworks. And we have to push the boundaries to implement our human rights into the domestic laws and policies. We are rising. Though in that rise, we must not make our work business as usual when we make these changes. We are slowly seeing changes in the legal system, a new framework on human rights for Indigenous people. Though one of the main challenges before us is to implement our human rights into the domestic framework. It is a task, and at times it seems impossible. We have started to begin the climb of the impossible mountain and have made changes as well as in the international arena. One of the main changes that has been made in the international arena was in the United Nations Declarations of the Rights of Indigenous People. This is a legal framework which is an international instrument which creates a comprehensive framework for Indigenous people's rights, approved by the United Nations in 2007 and endorsed in 2010, 150 nations around the world by 150 nations around the world. This is supposed to be the new order of the day for Indigenous peoples. Though we know our domestic laws and policies do not stack up to this declaration, and we know that they are supposed to comply with UN standards. In the domestic home front for Indigenous peoples have turned to various decolonisation strategies to antidote the colonisation, languages and culture restorations, to renew our land rights and our cultural and human rights, and a return to traditional governance food sovereignty and security, revival of ceremonies and spiritual practices, truth-telling, which is the most important, and the revision of our history and a return to traditional healing practices and our traditional knowledge. I will share with you some case studies in Australia in law as how we work towards self-determination that have brought changes in justice, actions, and decolonisation. I will not go into full details because of time limits, but I'm more than happy to speak to anyone requiring further information later. In Australia, we have started to climb that mountain to make changes to decolonisation and to bring justice to even the oppressive situation. One of the main doctrines that have affected Australia in colonisation is the doctrine of discovery. This doctrine was the first doctrine, is the key premises for the post-invasion on sovereignty over Aboriginal lands and territories. It was used in Australia, New Zealand, Canada and the United States to lay claim on territories uninhabited by Christians. If the land was vacant, they could then be defined as discovery and sovereignty claim. This gave explorers, including Christopher Columbus, to colonise and claim the land for themselves. On top of this doctrine in Australia, we had the doctrine of terra nullius, and it was a extreme version of the doctrine of discovery, and it was not overruled in the courts until 1992, and this was in the case of Mavo versus the State of Queensland. This took 10 years in the legal system. The court ruled that the land of Australia was not terra nullius, and the court inserted the legal doctrine of native title into the law, and that in fact was that people had lived in Australia for thousands of years and enjoyed the rights to their law according to custom. This may be great, but native title only gave us recognition before Captain Cook came along. And I'll just quickly explain to you what it is. So I'm a Kalkadoon Wanya. So my family had to prove that my father, my grandfather, and my grandfather's family were Aboriginal people in that area of the Kalkadoon Wanya area. So when our claim for determination to prove that we were all recognised as Aboriginal people before Captain Cook came along, 35 other families had to put claim for us to get determination. It's a real terrible process because there are some determinations that have not got up. There's only 500 determinations so far in Australia. All people in Australia have to go through this process to say that they are recognised before Captain Cook came along to give us recognition of who we are as Aboriginal and Torres Strait Islander people in our own country. While all this is going on, we had a landmark court case just recently in July. And this landmark court case, because one thing with native title, we are not allowed to make economic gain. So this landmark court case was a win about compensation for native title holders in Pine Creek for $2 million for their loss of spiritual and cultural loss and for the impact of our country. And I say good luck to everybody else who's a native title holder in Australia to try and get that compensation, because I can tell you now, my family won't receive that compensation way after I'm gone, because the process now for native title holders, the bar has gone up really high for them to even get determination. So, and also for compensation, they will be appealing, and the government is now only trying to look at negotiations for infrastructure rather than giving them monetary compensation. The cases that I will continue to talk about were two cases run by my son, who is a barrister in Australia, and these were landmark decisions for us in Australia as Indigenous peoples. The first one is about the Palm Island. The applicants are Mr. Lex Waterton, Miss Agnes Wharton and Cecilia Wharton. They brought this proceedings on their own behalf, on the behalf of the Indigenous community who resided on Palm Island on the 19th of November 2004 and who remained residents there until March 2010. This class action my son won last year was won, and the Queensland government have agreed to pay $30 million to 447 claimants from that one Aboriginal community, as well as interest and legal and administrative costs. This was against the state government concerning institutionalised racial discrimination within the Queensland Police Force in the event surrounding the death of Murungi Dumaji in police custody. An internal investigation, as we all know, clear the police all of the time of any wrongdoing. He was only in prison for half an hour, and within that time his injuries were massive internal injuries, including a broken ribs, ruptured spleen, and his liver was so badly damaged that it was almost cleaved in two across his spine. The community rioted when the verdict was handed down, and they burnt down the police station. The riot squad was sent in, over 300 police with dogs and taser guns and their other guns, and sent to a harmless Aboriginal community where they had no guns. Children were tasered, as well as pregnant women, and what happened was with this is that Lex went to a lawyer, the lawyer got my son, and what happened is that they used international charters were used in this case. The Charter of the United Nations on the Convention Against Torture and Other Cruel, Inhumane, Degrading Treatment or Punishment was one of the ones that they used. The International Convention on the Elimination of All Forms of Racial Discrimination, International Convention on Political Rights, International Convention on Economic, Social and Cultural Rights, and the Universal Declaration of Human Rights. So what happened was that after they won the case, the $30 million, of course the police don't want to pay any of us any money, or nor do the state governments. They made an appeal. Then my son, they called my son said to them, okay, make the appeal, we'll take it to the High Court. Bring it on, we got nothing to lose. So within another week they came back and settled the claim. So that $30 million will go directly to those 440 claimants in that one community. The other class action was a claim that he just won recently, was, and these are all setting precedents for us as Indigenous peoples, and you need to remember some of these international covenants that were used, and that as Indigenous people, getting together as a community and as class actions, that's what we have to do to overcome some of these laws. So what happened was with the class action, so wages were withheld from 1939 to 1972. So with the stolen wages, an estimate of 10,000 people in the state of Queensland who had their wages stolen will be paid at today's dollars and with interest. This was led by the applicant Hans Pearson, who took the Queensland government to the federal court to claim the wages he earned but did not receive. They had to give their pays at that time from 1939 to 1972 to the state government under the Protection Act. He argued that the state government breached its fiduciary duties by withholding the wages. The government had used unauthorised withdrawals and welfare fund deductions. So what happens is now is that this case was my son won it $200 million to 10,000 elders in my own state. That is direct cash payment with interest to all of them. That process will start next year. So on top of that, he had to turn around, and this is my son, he's worse than me. He then had to turn around and do it on behalf of Northern Territory and Western Australia. He's in the process of filing both those claims within the next month. If he wins, that means for those 3 states alone, it will be over $1 billion cash payments to our elders in those 3 states. These cases may take many years in the court, and we must remember that we must keep fighting and continue to keep trying, and even if we don't win, others may come along later. I'm going to also talk about some negotiations that we're looking at doing under our child protection. The United Nations Conventions on the Rights of Children is a human rights treaty which sets out the civil, political, economic, social, health and cultural rights of children. Before the doctrine of discovery and the child removal policies, which was where there were 1 in 3 children were taken from their families between 1910 and 1970s under the racist policies forcing Aboriginal people to assimilate and to get rid of the Aboriginal race. This year alone, in my state, there is currently 4,005 children in care. 17% of these children are with non-Indigenous family. And in my community, the region I live in, there are 700 children in care, Aboriginal children. Nationally, there is 17,664 Indigenous children currently in care. And our national number is 798,600. So we have 17,660 children in care. They have also now removed the Indigenous identity agencies where an Aboriginal person would negotiate with child services to put children in with families. So now what happens is that people just who have children who are in care, they just have to go to the table and negotiate against family services and self. We all know they're going to family services wipe the floor with Indigenous people on these issues because they always remove them. So what's happened is that one of the things is that the Central Queensland Aboriginal Organisation have asked me to, along with them, to review all the child right treaties, laws and policies, and to put a report together, to put a program with the courts to try and implement where these children can go, to try and get them with their next of kin, and also to maintain their culture. I will be working with the Chief Magistrate to have these, and with judges to place these in their orders for these children, and to make them aware that these children have rights and they have rights to be with family, because this is not happening at the moment and Child Protection are not taking any consideration in that. So what we have to do as Indigenous people, we have to go and negotiate ourselves. We have to get together as a collective and we have to go and make these changes. I know very well they're not going to change the law when it comes to child protection for Aboriginal and Torres Strait Islander children in our country. They're going to keep removing those. So a group of us have come together, we've decided, and as well as with the community support behind me and the organisation, we've decided we're going to write our own report and we are going to go to the magistrates where these orders are made to try and work with them to put these in place rather than go anywhere. Because it's up to us to make a stand, and somehow we have to look at different avenues and different ways to make those stands for us as Indigenous people, and especially for our children. If our children see we're not doing nothing, they're going to think nobody cares. So what's happened is that we've already been doing something like this in the courts for domestic violence, and I will be going out in November with them to ensure that there are translators in all our remote communities in Northern Territory and Western Australia. These are Aboriginal people. Aboriginal Torres Strait Islander people, English can be their third or fourth language, and when they go to court, some of them don't understand what the whole process is. And this is especially important for indictable offences. And what happened was, there was a case of a lady named Robin Kiner. She was charged with murder, she got life. No one really, she didn't understand the process and nobody really asked her the questions of what really happened. She didn't really speak English very well and she was a very shy person. But what happened was that while she was in prison, years later, she told somebody why she was there. She told them that she was being raped and beaten by her partner, and that on that day that she stabbed him, that he was going to go in and rape her niece, and that's why she went and stabbed him. She got off on provocation, and that was many years later. This is why it's important that we know how, that we give the right information to our people when they're going into court, and that they understand the court processes, because the legal system is very unkind to Indigenous people if we do not know how it all runs. We know that Indigenous people worldwide are suffering from international trauma. Health for Indigenous people is one of our biggest threats. This is why there are changes, and we have to take matters into our own hand for the benefit of us and to make changes for our future generations. And when we are negotiating at the table, we must negotiate for the next generation, not just for this generation. We are not funded or supported when we make these changes, so we have to self-fund ourselves at time. And I'll give you an example of self-funding, what happened in Australia. So in Australia, in mostly all the remote communities, that there's a if Aboriginal people in remote communities want any benefit for health, education, or the basic service of good housing or anything, they are to sign a 99-year lease, and the government will then give them some of it, maybe not all of it. So what happened out in a remote community in Kintor in South Australia, on the border of Western Australia and Northern Territory, was they were a small Aboriginal community. They asked the government if they could fund them for dialysis machine. They only wanted 2. They said, we don't want our elders going into town, and we don't want them staying in town and dying in town, because they will take our language with us, they take their culture, and we will start losing that. And that their children will start following. It's like a forced removal of what the government were trying to do. The government said, well, you sign your 99-year lease and then we'll give you what you want, your kidney dialysis and the doctor, and said everything. So what happened was they said no. You know what you can do with your money? They went and done an art expedition, and they sold over $1 million of painting and artworks. They then got in an Aboriginal doctor, and they brought their own kidney dialysis. They are now have run 13 clinics in a mobile clinic on themselves through self-funding. I've just got to wrap it up. So all of those people who I'm talking about, who were claimants to these cases and are community people, they did not have an education, but they all had a belief in themselves and their rights, as well as a strong spirit of hope and determination. The fight can take us years, and we may win some and we may lose some, but we must remember we had lost everything. Our land, cultures, laws, and some of us lost our language. But it is through our determination and our own passion for our human rights that we have taken up the challenge to decolonize the colonization that oppressed us. Our mothers and fathers and our grandparents who have walked before us. But it has been those who took up the challenge, and it is us who now must continue the challenge and pass that on to our children and the youth. So, my brothers and sisters, we must stay strong and continue to stand proud. And you've done that here in Guam by marching as a collective, and we are not invisible, and we are voices. And I'd quickly like to say, and I'd like this person to stand up, because people do not know that where I live, Shellwater Bay, Yeppoon, America has the largest military training on sea and land. Every year they send over 30,000 to train there for 6 to 8 weeks. And Guam actually sent a person to our protest. And if that lady would like to stand up over there, I would really like to acknowledge her. Thank you, and thank you to the Guam people. Thank you. So again, thank you all very much. Sisters and brothers, stand proud, stay strong. Thank you.
I think, we have a lot of issues just like you in regards to housing, health. As we know, health is the biggest threat for Indigenous peoples in the world. And, we don't have, remote communities don't have that access to health immediately. And so we generally all, Indigenous people around the world have quite a, very similar issues. Yep, the overview of it was mainly about, a bit about the international law, about the Declaration for Indigenous Peoples, the UN DRIP, and about the importance of that, and about how, you know, that was a foundation set down on a rule of law for Indigenous people worldwide, and for, you know, finally gave us that recognition of Indigenous peoples. And, you know, it's, you know, I think we're 150 countries have signed on to that, so that's a really big thing. And also quickly spoke about the court cases that were happening in Australia, and also about, you know, about self-funding, and also about, you know, we have to remember that Indigenous people were resilient, and it's about that resilient. It was about that, who we are, who our foundations are, and how we're like a tree. You know, we're rooted to the grounds, and that's why we've got to stand strong, and it'll take a lot to bring us down. The hospitality here and the people that I've met, it's been excellent, and I just wish them the very best in moving forward and continue the fight. It's a very, very, very hard fight, you know, and as I said yesterday, you know, we have to climb the impossible mountain, but we have to make that possible, and we will. You know, things may not happen straight away, but what we're fighting for now may come to throw in another 20 years. And that's what Guam, you know, this conference was about unity as well for Guam. And it was about sharing information from the international arena and other countries, so that, you know, we can provide that to Guam in their struggles for what they're doing now. But really it isn't a struggle. We've all been in a warfare. Information is power. And, you know, bringing another voice shows Guam that they're not alone in their walk, and that's why I wish them all the best, because they're not alone. 500 million Indigenous people backing you.